Good morning. Welcome back to Wicked Wise. So we're going to go through some more of these cases. I'll put them in the description below. And you need to share these videos because people need to learn before CPS shows up at your door. So let's get started. Okay. Absent extraordinary circumstances, a parent has a liberty interest in familiar association and privacy that cannot be violated without accurate pre-deprivation procedures. I'll put these cases in the description below. Don't take my word for it. Look them up yourself. The court held where abusive government action by a member of an executive branch is alleged, only the most egregious official conduct can be said to be arbitrary in the constitutional sense. State employee, okay, that would be a CPS worker, who withheld a child from their family may infringe on the family's liberty and familiar association. Social workers cannot deliberately, you hear this? Social workers cannot deliberately remove a child from their parents and place them with foster caregivers when the officials reasonably should have known such actions would cause harm to the child's mental and physical health. Under this standard, action will not expose the official to liability unless it is so ill-conceived or malice that it shocks the conscience. The court emphasized that Croft was simply an application of a traditional substantive due process shocks the conscience standard, stating that only in rare circumstances can allegations of a neglect be so severe or credible that an investigation into the allegations is not required for removal. A defendant in a civil rights case is not entitled to any immunity if he or she gave false information either in support of an application for a search warrant or in presenting evidence to a prosecutor in which the prosecutor based his or her charge against the plaintiff. Remember, I'm going to put all these cases and I'll put them in order. The court held that CPS workers acting on an anonymous tip with multiple layers of hearsay without any corroborating evidence or without any evidence that convinced her one way or another that there was any sexual abuse involved had significant jurisdictional for such dramatic infringement on the parental and child's rights. Fourth Amendment protects against unreasonable searches and seizures, extends beyond criminal investigations, and includes conduct by social workers. Court held that an anonymous tip standing alone never accounts for probable cause. Defendant should have investigated further prior to ordering the seizure of a child based on information he overheard. The possibility of danger does not constitute an emergency or exigent circumstances would justify a forced warrantless entry or a warrantless seizure of a child. In context, a seizure of a child by the state during an abuse investigation, a court order is equivalent to a warrant. Okay? So what they're saying is, you know how they go and do an ex parte, because that's what they do. They go to court without you, which is a violation of your 14th Amendment right too. So if you look up ex parte in a law book or a paralegal book, beside ex parte, it says unethical. So anyway, child protective workers are subject to the 4th and 14th Amendment in the context of an investigation of alleged child abuse or neglect, as are all government officials. Now remember, I keep telling you, nobody from the president to a bum in the street is above the Constitution. The court ruled, despite the defendant's quote unquote CPS worker, I lost my place. The defendant's CPS worker aggressively viewed their powers, and the 4th Amendment applies to them as it does to all officers and agents of a state whom request to enter. However, well-intended are met by a closed door. The 4th Amendment prohibits on unreasonable searches and seizures applies whenever an investigator, be it the police officer, a CPS employee, or any other agent of the state, responds to alleged instance of abuse and neglect. So when they tell you that you have no rights, that's bull. You have just as much right as they do. In fact, you know what I would ask them? If they say you have no rights, ask them who died and left them above the Constitution. Better yet, ask them if they know their rights. The Constitution also protects individual interests in avoiding disclosure of personal matters governed by federal courts and state courts. Under life, liberty, and pursuit of happiness, phrased in the Declaration of Independence, the right of a man to enjoy the mutual care, company, love, and affection of his children. And this cannot be taken away from him without what? The 14th Amendment Due Process Clause. There is a family right to privacy, 4th Amendment, which the state cannot invade or becomes actionable, or it becomes actionable for civil rights damages. So when they tell you that you can't sue them, no, you can't sue the department, but you can sue them. And if you want to sue the state or the county, well, actually the state, you have to write your attorney general and tell the attorney general that you're suing the state, because they have to agree to be sued. And 9 times out of 10, the state's not going to agree to be sued, right? But you can sue a CPS worker, okay? So don't let them tell you that you can't, because that is incorrect. The court focused on the information available to the defendants at the time would have created an objectable, reasonable suspicion of abuse, justifying the degree of interference with the parents' rights as the child's parents. In the absence of such reasonable grounds, the government instructs of the obstructions the nature of arbitration, and it abuses its power. They abuse their power. They don't have power. You give them the power when you answer their questions under the 5th Amendment. Just shut up. Shut up. If you've watched my videos, I told that CPS worker, and the police did not say a word because they already knew. You have the right to privacy, okay, under your 4th Amendment right, okay? Your child has the same right. You just hold those rights. Under the 5th Amendment, you have a right to shut up. Do it. Shut up. Don't answer them. If you want to answer them, answer them with a question. Why are you here? What was the complaint? And if they want to come in your house, ask them where their warrant is. If the police are there, ask the police why they're there, right? Because the only thing they can do is protect the CPS worker, right? Go to her house, try to steal her kid. It's not going to happen. Your ass will be in jail. A due process violation occurs when a state-required breakup of the natural family is founded solely on the best interest analysis that is not supported by the proof of the parent's unfitness. The Supreme Court held that testing without your consent for the purpose of a criminal investigation violates your Fourth Amendment right. Don't pee in a cup. Don't agree to have your blood work done. Don't do anything. Tell them to take it to court. I see we're running up on 11 minutes. I'm going to stop right there. Look all these cases up. Start using them. If you need a copy of it, let me know. I will email you this whole 154 cases. And with that, have a great day.